Hello friends, welcome to Defense IAS Academy. Our today's topic is on political science. So, political science and international relations is one of the optional subjects that is offered by UPSC. It's like political science, you have it in the prelims as well as in the mains. It is an informative and a necessary subject for anyone who is preparing for the civil service exam. There are many reasons why political science is considered as a scoring subject and a best optional subject in UPSC. The one thing is that political science can be understood by anyone, and you need not have a political science background to understand it. So it is considered one of the most good optional subject in case of UPSC and a very good scoring subject. So let us start with a few recurring questions asked for the UPSC exams. Question 1. Via which of the following amendments the term socialist was inserted in Preamble of Indian Constitution? The correct answer is option B, 42nd Amendment Act. By the 42nd Amendment, that is Constitutional Amendment Act, which was given in the year 1976, 3 new words were added to the preamble of the Constitution. They were socialist, secular, and integrity. Which among the following articles defines the money bill? So the article, the correct answer is Article 110, that is the option A. Only those financial bills which contain provisions exclusively on matters listed in the Article 110 of the Constitution are called money bills. So what's a money bill? It is defined in the Article 110 of the Indian Constitution, and it is concerned with the financial matters like taxation, public expenditure, etc. A bill is said to be a money bill only if it contains provisions related to taxation, borrowing of money by the government, expenditure from or receipt of the consolidated fund of India. Third question, which among the following was the strength of Lok Sabha after India's first general election? The answer is option C, 489. At that time, maximum strength of Lok Sabha was 500 members and all elected members were 489. Question 4. In which year Constitution of India was amended for the first time? In which year the Constitution of India was amended for the first time? The answer to the question is option B, 1951. The Constitution First Amendment Act was in the year 1951, enacted in 1951, had made several changes to the provisions related to fundamental rights to check abuse of freedom of speech and expression, validation of semindari abolition law, etc. This amendment provided that right to equality does not bar the enactment of laws which provide special consideration for weaker sections of the society. Question 5. Which session of the Constituent Assembly took place on which of the following dates? The correct answer is option A, 9 to 23 December 1946. So the question was, the first session of the Constituent Assembly took place in which date? So the correct answer is 9 to 23 December 1946. The first meeting or session of the Constituent Assembly took place in the year 1946, and on the dates 9 to 23 December, it was held in a constitutional hall which was in New Delhi, and Dr. Sachidananda Sinha was the first president of the Constituent Assembly. So what happened in the first meeting? In the first meeting, the Assembly adopted an objective resolution which later became the preamble of the Constitution. We can say that the first meeting, they had an objective which became the preamble, which later became the preamble of the Constitution. It appointed various committees. The report of the committees formed the basis on which the first draft of the Constitution was prepared. It reassembled on 14th August 1947 as Constituent Assembly of Independent India. So the Constituent Assembly of Independent India was first held in or reassembled in 14 August 1947. After partition, Dr. Rajendra Prasad became the first president of the Constituent Assembly of Independent India. So the president of the Constituent Assembly before independent India, or before India became independent, was Dr. Sachidananda Sinha, and after the partition, Dr. Rajendra Prasad became the president of the India once it became an independent country. Professor Harendra Kumar Mukherjee was Vice President of the Constitution Assembly, while Dr. Rajendra Prasad later became President of India. Professor H.C. Mukherjee became first Governor of the West Bengal. Question 6. Who was the first Chief Election Commissioner of India? Who was the first Chief Election Commissioner of the India? The correct answer is option C, Sukumar Sen. Sukumar Sen from the year 1898 to 1963 was an officer of the Indian Civil Services. He was the officer of the Indian Civil Services, and he was the first Chief Election Commissioner. First Chief Election Commissioner of India. He served from 21st March 1950 to 19th December 1958. Two general elections like via 1951 to 52 and 1957 were administered under his watch. So the Sukumar Sen became the election commissioner of India, and under him there was two elections held in India in the year 1951-52 and 1957. Seventh question, which of the following committee made a recommendation that election commission should be a 3-member body? So the correct answer is option A, Tarkunde Committee. Tarkunde Committee. In 1974, as President of Citizens of Democracy, Jayaprakash Narayan has set up a committee under the chairmanship of Justice V.M. Tarkunde to study and report on a scheme for electoral reforms. This committee, apart from other recommendations, had advocated for a multi-member election commission in India. Question 8. Which amendment restored the power of judicial review of the Supreme Court and High Courts that were earlier curtailed by Constitution 42nd Amendment Act 1976? So the answer to the question is option A, 43rd Amendment Act. 43rd Amendment Act, which was in the year 1977. The Constitution's 43rd Amendment Act in the year 1977 restored the jurisdiction of Supreme Court and the High Courts in respect of the judicial review and the issue of writs. The Contingency Fund of India has been placed at the disposal of which among the following authorities? So the answer is option B, President of India. The Contingency Fund of India has been placed at the disposal of President of India. On the other hand, contingency funds of the state governments are at the disposal of the governor. So contingency funds of India is with the President of India, and for state it's with the governor of the state. The Contingency Fund of India was established under the Article 267 of the Indian Constitution. It was established under the Article 267. So, and this article, it's like says that the contingency fund is a fund that is designed to be used for meeting any unforeseen emergencies and maybe either in cash or in liquid assets. The primary objective of this contingency fund is to enhance your financial stability and to protect your financial plan in case of emergencies. What is the number of items in 12th schedule added by the 74th Amendment of the Constitution? What is the number of items in the 12th schedule added by the 74th Amendment of the Constitution? The correct answer is option C, 18. Correct answer is option C, 18. Now the 74th Amendment added in the 12th schedule in the Constitution comprising 18 items that fall under the purview of the municipalities. So what are these 18 items that come under the 74th Amendment? One is urban planning including town planning, then regulation of land use and construction of buildings, then planning of economic and social development, roads and bridges, water supply for domestic and industrial and commercial purposes, public health, sanitation, conservancy and solid waste management, fire services, urban forestry and protection of environment and promotion of ecological aspects, then safeguarding the interest of the weaker sections, then slum improvement and upgradation, urban poverty alleviation, provision of urban amenities and facilities, promotion of cultural, educational and aesthetic aspects, burials and burial grounds, cremation grounds and electric crematoriums, cattle ponds, prevention of cruelty to animals, vital statistics including registration of birth and deaths, public communities including street lights, parking lots, bus stops and public conveniences, regulation of slaughterhouses and tanneries. So these are the 18 items that fall under the 74th Amendment of the Constitution. In which schedule of Indian Constitution the territorial extent of Indian states and union territories is prescribed? The answer is A. Option A, first. First schedule lists the states and territories of India, list any changes to their borders and the laws used to make that changes. Next question, which constitutional amendment gave right to education to children in India? The answer is option A, 86th Amendment. Constitution's 86th Amendment Act 2002 made elementary education a fundamental right in India. It added new article 21A, which declared that state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may determine. It also changed the subject matter of Article 45 in DPSP, which now reads, State shall endeavour to provide early childhood care and education for all children until they complete the age of 6 years. It also added a new fundamental duty under Article 51A, which reads, It shall be the duty of every citizen of India who is a parent or guardian to provide opportunities for education to his or her child or ward between the ages of 6 and 14 years. Question 13. Which of the following article deals with citizenship at the time of commencement of the Constitution? Answer is Article A. The Article 5, that is option A, Article 5. Article 5 of the Indian Constitution dealt with the citizenship of the citizenship at the commencement of the Constitution. This article says that the commencement of the Constitution, every person who has the domicile in the territory of India and who was born in the territory of India, either of whose parents were born in the territory of India, who has been ordinarily resident in the territory of India for not less than 5 years preceding such commencement, shall be a citizen of India. So these are the conditions to be a citizen of India. Either you are born in the territory of India, or either of your parents are born in the territory of India, or who has been the resident in the territory of India for not less than 5 years can become or shall become the citizen of India. So the Article 5 of the Indian Constitution deals with the citizenship of India, or citizen or decides who can be a citizen of India. Next question 14. Which of the following President of India was the only person to be elected unopposed? So the correct answer is option C, 6th President. Neelam Sanjeeva Reddy was the only person to be elected unopposed. Who was it? Neelam Sanjeeva Reddy. He was the only person to be elected unopposed. He was the 6th President of India. Next question. Which of the following presidents of India headed the Indian Society of Labour Economics founded in 1957? Answer to the question is option B, V.V. Giri. Indian Society of Labour Economics was founded in the year 1957 by a distinguished group of academicians and public men engaged in promoting the study of labour and industrial relations. The group was headed by the ex-president of India, Sri V.V. Giri, and composed of some of the biggest names in academia. Which among the following article throws all public places to all citizens? The answer is option A, Article 15 of 2. Article 15 of 2 says that no citizen shall on grounds only of region, race, caste, sex, place of birth, or any of them be subject to any disability, liability, restriction or condition with regard to 1. Access to shops, public restaurants, hotels and places of public entertainment. B. The use of wells, tanks and bathing ghats, roads and places of public resort maintained wholly or partly out of the state funds or dedicated to the use of general public. So the article 15 of 2 says that all the public places are for all the citizens of India, regardless of the religion, race, caste, sex, place of birth, or any of them, and regardless of their disability, liability, or restrictions or conditions given to them. Question 17. Which among the following freedoms guaranteed by Constitution of India includes the right to know and the right to be informed as implied rights? So the answer is option A, freedom of speech and expression. Article 19 of 1A includes the right to know and the right to be informed. It includes the right to know and the right to be informed. It's worth to note that media, that is print and electronic, are the eyes and ears of the citizen, and unless media freedom to report court proceedings is protected, the right to know is impaired. So the freedom is guaranteed by Constitution of India, like the right to know and the right to be informed is from the Article 19 of 1, which includes 19 of 1, which says freedom of speech and expression. Freedom of speech and expression. Next is 18. Which of the following committee of Parliament considers the question of contempt of the House? The answer is option B, Committee on Privileges. Both Lok Sabha and Rajya Sabha have their Committee on Privileges. The Lok Sabha committee has 15 members. The Lok Sabha committee has 15 members, while the Rajya Sabha has 10 members. The members are nominated by the Speaker, Chairman, as the case may be. The functions of the committee are semi-judicial in nature, including examination of breach of privileges of the House. The committee recommends appropriate action. So, the Committee on Privileges says or is the committee of the Parliament that considers question of contempt of the House. Next question. With reference to the scheduled areas, who among the following is empowered to direct that an act of Parliament does not apply to a scheduled area? I'll read it once more. With reference to the scheduled areas, who among the following is empowered to direct that an act of Parliament does not apply to the scheduled area? Answer to the question is option B, Governor of the state. In scheduled areas, the governor is empowered to direct that an act of Parliament does not apply to scheduled area in the state or apply with the specific modification and exceptions. So the governor is the person who say that whether an act or whether an act is directly applicable, whether it is directed to a scheduled area or whether it is applicable to a specific scheduled area, or a certain modification or exceptions are needed for that law to be enacted to that particular scheduled area. So the governor of the state decides it. Question 20. Article 32 of the Constitution of India guarantees the right to move the Supreme Court for enforcement of fundamental rights. This falls under which among the following kinds of jurisdiction of the Supreme Court? The answer to the question is option A, original jurisdiction. Moving to Supreme Court or High Court in case of violation of the fundamental right comes under the original jurisdiction. Question 21. Which of the following is incorrect about Indian Independence Act? Which of the following is incorrect about the Indian Independence Act? The answer is the option D. British monarch retained his right to veto bills for certain period. Answer is D. The British monarch retained his right to veto bills for a certain period. The British monarch was deprived of his right to veto bills or asked for reservation of certain bills for his approval after this act. Question 22. Who held the portfolio of external affairs and Commonwealth relations in the first cabinet of Free India? Answer is option A, Jawaharlal Nehru. Option A, Jawaharlal Nehru is the correct answer. Jawaharlal Nehru was the first Prime Minister of India, of Free India, held the portfolio of external affairs and Commonwealth relations. He also had the portfolio of scientific research in the first cabinet of Free India. So he was he held the portfolio of external affairs and Commonwealth, and also the scientific research portfolio for the scientific research in the first cabinet of Free India. Next question, on which date first meeting of the Constituent Assembly was held? The answer is option A, 9th December 1946. 9th December 1946. The first meeting of Constituent Assembly was held on 9th December 1946. The first meeting, the very first meeting of the Constituent Assembly was held on 9th December 1946. The meeting was not attended by the members of the Constituent Assembly. The meeting was also boycotted by the Muslim League. Several features of the Constitution of India have been borrowed from different sources. Which of the following is not a correct match in this context? So the option says that the Government of India Act 1935 came from the federal scheme. Then it says the British Constitution gave the concurrent list. Then the US Constitution gave the fundamental rights. The Japanese Constitution gave the procedure established by law. So we have to choose the one that is not correct, the match that is not correct. Answer is option B, British Constitution giving the concurrent list. Jawaharlal Nehru was the Vice President of the Executive Council, External Affairs and Commonwealth Relations in the first as well as second interim cabinet. The President was Lord Wavell, Viceroy and Governor General of India. So that is the incorrect match over here. British Constitution giving the concurrent. So if it was not concurrent list taken from British Constitution, what was taken from the British Constitution? So the things that was borrowed to the Indian Constitution from the British Constitution is parliamentary government, the rule of law, legislative procedure, single citizenship, cabinet system, prerogative writs, parliamentary privileges. Those all were the things that were taken from the British Constitution to the or borrowed from the British Constitution to the Indian Constitution. Next, the Constitution of India is considered federal in nature and unitary in spirit. Which of the following is not a federal feature? The answer to the question is option D, appointment of state governors by the central government. The appointment of state governors by the central government is not considered a federal feature. The Constitution is considered a federal in nature and a unitary in spirit. It has features of a federation, that is a codified supreme constitution, a three-tier governmental structure, central, state and local, division of powers, bicameralism and an independent judiciary, and then and the unitary features such as single constitution, single citizenship and integrated judiciary, a flexible constitution, a strong central government, appointment of state governors by central government, all India services, that is IAS, IFS, IPS and emergency provisions. This unique combination makes it a quasi-federal in form. So all these together, the unitary feature and the federal features together forms or all these combinations together make our constitution a quasi-federal in form. Who called preamble the identity card of the Constitution? The answer is option C, N.K. Palkhiwala. Yes, N.K. Palkhiwala called the preamble as the identity card of the Constitution. He was an eminent jurist and a constitutional expert. He was revered in India as top authority on constitutional law and government finance. So please keep in mind the preamble was called as an identity card of the Constitution by N.K. Palkhiwala. N.K. Palkhiwala. Question 27. India had transferred Godavari territory to which of the following countries? The answer is option A, Pakistan. In Godavari Union case, India transferred a part of the territory, the Pakistan, present Bangladesh. Supreme Court held that the power of Parliament to diminish the area of a state does not cover the cession of Indian territory to a foreign territory. Next question. Which of the following categories of persons becomes the citizen of India at the commencement, that is on January 1950? 1 persons domiciled in India, 2 persons migrated from Pakistan, 3 persons migrated from Pakistan but later returned, then fourth is person of India origin residing outside, person of Indian origin residing outside India. So among these categories, who are called the citizens of India? Select the correct option from the codes given below. Now the answer is option D, all of the above. All of the above categories called as the citizens of India. According to the Constitution, 4 categories of persons become the citizens of India. Who are all that? A person who is domiciled in India, a person who has migrated from Pakistan, a person who has migrated from Pakistan, a person who has migrated to Pakistan but has later returned back, then a person of Indian origin residing outside India. All of them were considered to be citizens of India. Next, in context with the writ jurisdiction of Supreme Court and High Courts, which of the following is a correct statement? The answer is option B. Supreme Court's writ jurisdiction is narrower than the High Court. The Supreme Court can issue writs only for the enforcement of fundamental rights, whereas the High Court can issue writs not only for the enforcement of fundamental rights but also for the enforcement of an ordinary legal right. Thus, the writ jurisdiction of the Supreme Court is narrower than that of an High Court. Next question. Which of the following articles grant that right to equality to citizen of India? So, which of the articles grant that right to equality to the citizen of India? The answer to the question is option B, Article 14 to 18. Article 14 to 18. The right to equality is enshrined in Article 14 to 18 of the Constitution of India. Article 14 says that the state shall not deny to any person equality before the law or the equal protection of the law within the territory of India. Next one, what is the maximum number of members that a parliamentary forum can have? Maximum number of people a parliamentary forum can have. Answer is option D, 31. A parliamentary forum consists of not more than 31 members, excluding the president, co-president and vice president. President, co-president and vice president. So in this count 31 they are not included. Out of the 31, not more than 21 are from Lok Sabha and not more than 10 from Rajya Sabha. So in the 31 given, the total count 31 given, 21 are from Lok Sabha and 10 are from Rajya Sabha. 10 are from Rajya Sabha. So the total number of members is 31. Next question, who is authorized to increase the number of judges in the Supreme Court of India? So who can increase the number of judges in the Supreme Court of India? Answer is option B, Parliament. The Article 124 of the Constitution of India. Which article? Article 124. What it does, it say it provides for the formation of the Supreme Court of India. The power to increase the number of judges in the Supreme Court of India is vested in the Parliament. So according to Article 124, the Constitution of India provides facility, or provides the option that the number of judges in the Supreme Court of India can be increased by the Parliament. Now question 33, against which judge of Supreme Court the first case of impeachment initiated? So the answer is option A, V. Ramaswamy. The first case of impeachment was of Justice V. Ramaswamy of the Supreme Court from 1991 to 1993. The inquiry committee found him guilty of misbehavior. Still, he could not be removed as the impeachment motion was defeated in Lok Sabha. The Congress party abstained from voting. Question, who can punish any person for the contempt of the Supreme Court? The answer to the question is option D, Supreme Court. The Supreme Court of India can punish any person or for its contempt. Therefore, the actions and decisions of Supreme Court can be criticized and opposed by anybody. The power is vested in the Supreme Court of India to maintain its authority, dignity, and honor. Under which of the following the power of the Supreme Court of India to decide disputes between the sender and the state falls? Answer is option D, original jurisdiction. The Article 131 of the Indian Constitution deals with the original jurisdiction of the Supreme Court of India. The Supreme Court has original jurisdiction in disputes between the sender and one or more states, or between sender and any state or states on one side and one or more other states on the other side, or between two or more states. So under the original jurisdiction, the Supreme Court of India has the power to decide the disputes between the center and the state. It is described in the Article 131 of the Indian Constitution. Next question 36. Which constitutional principles are upheld through judicial values? So the question is, which constitutional principles are upheld through judicial reviews? The answer to the question is option C, both of them. Upholding the supremacy of the Constitution and protecting the fundamental rights. Both of these principles are upheld through the judicial review. So judicial review is required to uphold the principle of the supremacy of the Constitution, to maintain the federal equilibrium, and to protect the fundamental rights provided within the Constitution. Next question 37. Who can make regulations for the peace, progress, and good government of the Union territories? Answer is option D, the President. The President of India can make regulations with respect to the peace, progress, and good government of the 5 Union territories: the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu, and Ladakh. So the President of India can make regulations with respect to peace and progress and good government for the Union territories. 38. Which interstate water tribunal was constituted for the state of Odisha and Chhattisgarh? The answer is option D, Mahanadi Water Dispute Tribunal. The option D is the correct answer, Mahanadi Water Disputes Tribunal. The Mahanadi Water Disputes Tribunal was constituted in the year 2018 by the central government for the state of Odisha and Chhattisgarh. The decision of the tribunal is final and binding on the parties to the dispute. 39. Which of the following committees advocated the establishment of a permanent interstate council under Article 263 of the Constitution? The answer is option A, Sarkaria Commission. It was the Sarkaria Commission on Center-State Relations in the year 1983 to 88 which made a strong case for the establishment of a permanent interstate council under the Article 263 of the Constitution. Question 40. Which Constitutional Amendment Act substituted the words armed rebellion for internal disturbances in the Article 352? The answer is option C, 44th. The 44th Amendment Act of 1978 to the Constitution of India had substituted the word armed rebellion. It says substituted the word armed rebellion for internal disturbances. Substituted internal disturbances with the armed rebellion. So, national emergency can no longer be declared on the ground of internal disturbances as was done in 1975 by the Congress government headed by Indira Gandhi. So, the 44th Amendment, which was of 1978, it substituted the word internal disturbances to armed rebellion. Next question, who is the ex officio president of all the parliamentary forums? The answer is option C, Speaker. The Speaker of Lok Sabha is the ex officio president of all the parliamentary forums except the Parliamentary Forum on Population and Public Health. The chairman of Rajya Sabha is the ex officio president and speaker in the ex officio co-president Parliamentary Forum on Population and Public Health. Next question, in which year did the Supreme Court declare the National Judicial Appointments Commission Act unconstitutional and void? So, when was this act made void? The NJAC Act, when was it made void? The answer is option C, 2015. So, the Supreme Court of India has declared both the 99th Constitutional Amendment as well as the National Judicial Appointments Commission NJAC Act as unconstitutional and void in the year 2015. In which of the following situation ad hoc judges are appointed in the Supreme Court? The answer is option B, when there is no quorum of judges available to hold a session. As per the Article 127 of 1 of the Constitution of India, at any time, if there should not be a quorum of judges of the Supreme Court available to hold or continue any session of the court, the Chief Justice of India, with previous permission of the President and after consultation with Chief Justice of the High Court, concerned request in writing the attendance at the sitting of the court as an ad hoc judge for such a period necessary. So, the Supreme Court means the ad hoc judges can be appointed in the Supreme Court when there is no quorum of judges available to hold the sessions. Against which judge of Supreme Court the first case of impeachment initiated? The answer to the question is option A, V. Ramaswamy. The first case of impeachment was of Justice V. Ramaswamy of the Supreme Court in the year 1991 to 1993. The inquiry committee found him guilty of misbehavior. Still, he could not be removed as the impeachment motion was defeated in the Lok Sabha. The Congress party abstained him from voting. I think this question is repeated one. Question 45. Which article of the Constitution deals with a dispute arising out of any pre-Constitution treaty, agreement and covenant? The answer is option A, Article 143. Article 143 of the Indian Constitution authorizes the President to seek the opinion of the Supreme Court on the following matters. 1. On any questions of law or fact of public importance which has arisen or which is likely to arise. Second, on any dispute arising out of any pre-constitution treaty, agreement, covenant, engagement, sanad or other similar instruments. Next question. Who was appointed as the chairman of 6-member Administrative Reforms Commission in 1966? The answer is option D, Morarji Desai. The 6-member Administrative Reforms Commission ARC in 1966 under the chairmanship of whom Morarji Desai, under the chairmanship of Morarji Desai, followed by K. Hanumantaya, was appointed by central government. It was to examine the various issues in the center and the state relationships. So, the Morarji Desai was appointed as the chairman of ARC in 1966 to examine the various issues between the center and the state relationships or relations. Which of the following committees advocated the establishment of a permanent interstate council under Article 263 of the Constitution? Answer to the question is A. Sarkaria Commission. It was a Sarkaria Commission on Central State Relations 1983 to 88, which made a strong case for the establishment of a permanent interstate council under Article 263 of the Constitution. Question 48. Who is empowered to declare national emergency under Article 352? So, who has that power to declare the national emergency? The answer is option D, the President. The President can declare a national emergency when the security of India or a part of India is threatened by war or any external aggression or armed rebellion under the Article 352. So, the Article 352 says that the President has the power. The President has the power to declare a national emergency when there is a threat for a part of India or for the full security of India. Question 49. Which of the following are the grounds on which national emergency can be declared? 1. External aggression. 2. Internal disturbances. 3. Armed rebellion. 4. Communal riots. Select the correct option from the codes given below. The answer to this question is D. Only 1 and 3. So, for only the situations external aggression and armed rebellion, national emergency can be declared for India. The Constitution mentions that only 3 grounds on which the President can declare a national emergency. One is when the security of India or a part of it is threatened by war or external aggression or armed rebellion. Which of the following are affected due to national emergency? 1. Center-state relation. 2. Life of the Lok Sabha and State Assembly. 3. Fundamental rights. So, which of the following are affected? Select the correct option from the codes given below. The correct answer to this question is option D, all of the above. So, all of this stated things like the center-state relations, the life of Lok Sabha and state assembly, fundamental rights, everything is affected and if there is a national emergency. A proclamation of emergency leads to drastic and wide-ranging effects on the political system of the country. The proclamation has effect on the center-state relations, life of Lok Sabha and the state assembly and on the fundamental rights. So it has an impact on everywhere. When you declare a national emergency, it has lots of consequences too. Which of the following article of Indian Constitution contains provisions regarding curative petition? So which article has provisions containing curative petition? The answer is option Article D, that is Article D, Article 142. Option is D. The option is correct. Answer is option D. The Article 142. The Supreme Court came up with the concept of curative petition in the case of Rupa Ashok Hura versus Ashok Hura 2002. According to the decision of the Supreme Court, of India, the curative petition can be appealed in the Supreme Court under Article 142 of the Constitution. Next question, which of the following can be judicially reviewed? Which of the following can be judicially reviewed? The correct answer is all of the above. That means the constitutional amendments, the legislation of the parliament, the legislation of state assembly, all can be judicially reviewed in the case of not in the case of, it can be judicially reviewed. Constitutional amendments, legislation of the parliament and state legislatures are subordinate legislation, administrative action of the union and state, and authorities under the state are all judicial review. What are the limitations on the sovereignty of Parliament in India? Answer is option D, all of the above. A written constitution, federalism with the division of powers between the center and the states, the fundamental rights and the judicial review are the limitations on the sovereignty of Parliament in India. Who appoints the judges of the state high court? Answer is option D, President in consultation with the Chief Justice of India and the Governor of the state. So, President with the helps from consultation from Chief Justice of India and Governor of the state appoints the judges of the state high court. Judges of the state high court are appointed by the President in consultation with the Chief Justice of India and the Governor of the state. The President can also transfer and remove them. Next question 55. Which of the following is not a party to Godavari Water Disputes Tribunal? Answer is option B, Madhya Pradesh. The state of Madhya Pradesh is not a party to Godavari Water Disputes Tribunal. The Godavari Water Disputes Tribunal was constituted in the year 1969. The states involved are Maharashtra, Karnataka, Andhra Pradesh, Madhya Pradesh and Odisha. So those are the states that are involved: Maharashtra, Karnataka, Andhra Pradesh, Madhya Pradesh and Odisha. So these are the states that are involved in the Godavari water disputes tribunal. Who is the chairman of the Interstate Council? Answer is option C, the Prime Minister. The Interstate Council consists of Prime Minister as chairman. The other members include Chief Ministers of all the states, then Chief Ministers of Union Territories having legislative assemblies, administrators of Union Territories and not having legislative assemblies, governors of the state under President's rule, and 6 central cabinet ministers including the Home Minister to be nominated by the Prime Minister. So the Interstate Council consists of Prime Minister as a chairman with all the other members who have been listed. Next question, 57. Which of the following are the grounds on which national emergency can be declared? 1 is external aggression, 2 is internal disputes, 3 is armed rebellion, 4 is communal riot. Select the correct option from the codes given below. I think this question is also a repeated one. Let's see the answer. Answer is option D, only 1 and 3. This is a repeated question. So external aggression and armed rebellion is the armed rebellion are the reasons for national emergency declaration. The Constitution mentions only 3 grounds on which the President can declare a national emergency when the security of India or part of it is threatened by war or external aggression or armed rebellion. Next is what are the reasons given for the practice of judicial activism? So the answer to the question is option D, all of the above. When the legislature and the executive fail to discharge their functions, leading to the erosion of confidence in the Constitution, judiciary steps in to protect the rights and freedoms of citizens. Moreover, there are areas which have not been legislated upon, leading to legislative vacuum that is filled by the judiciary through judicial activism. So the reasons given for practice of judicial activism are the failure in the legislature and executive to discharge their functions. Citizens look up to the judiciary for the protection of their rights, and legislative vacuum. So these are the reasons for practice of judicial activism. Next, who administers the oath of office to the governor? Answer to the question is Chief Justice of the State High Court. The oath of the office to the governor is administered by the Chief Justice of the State High Court. In his absence, the senior most judge of the court available is responsible for administering the oath. 60. Which of the following statements are correct regarding the promulgation of ordinances in the state? The answer is C, both of them. That is, governor can promulgate ordinances when the state legislature is not in session, and governor can withdraw any ordinance any time. So these two are the correct things, or correct regarding the promulgation of ordinances in the state. An ordinance can be promulgated by the governor when the state legislature is not in session. However, such an ordinance has to be approved by the state legislature within 6 weeks from its Reassembly. The government can also withdraw an ordinance when required. What kind of areas are administered by the notified area committee? Answer to the question is option C. Both of them means fast developing town due to industrialization is also considered, and a town is considered important by the state government. A notified area committee administers two types of areas. One is the fast developing town due to industrialization, and second is a town that yet not fulfills all the conditions necessary for the constitution of a municipality, but nonetheless is considered important by the state government. Which of the following UTs has its own high court? UT is Union Territory. Which of the following Union Territory has its own high court? Answer is option B, Delhi. Delhi is the only Union Territory that has its own high court since 1966. The Bombay High Court has jurisdiction over Dadra and Nagar Haveli and Daman and Diu. Andaman and Nicobar Islands, Chhattisgarh, Lakshadweep and Puducherry come under the Calcutta, Punjab and Haryana, Kerala and Madras High Courts respectively. 63. Which of the following are tribal areas located in Mizoram? Which are the following tribal areas located in Mizoram? The answer is option C, only 1, 2 and 3. Means the Chakma district, the Mara district and the Lai district are the three districts that are located in the Mizoram. The following are the tribal areas located in Mizoram: the Chakma district, the Mara district and the Lai district, whereas the Jaintia Hill district is located in the state of Meghalaya. Question 64. Where is the headquarters of Insurance Regulatory and Development Authority of India? The answer is option C, Telangana. The IRDAI, that is the Insurance Regulatory and Development Authority of India, is headquartered in Hyderabad in Telangana. It is an apex body responsible for regulating and developing the insurance industry in India. It is an autonomous body and statutory body. 65. In which year was the National Human Rights Commission established? In which year was the National Human Rights Commission established? Answer is option C, 1993. The National Human Rights Commission is a statutory body which was established in 1993 under a legislation enacted by the Parliament of India, namely the Protection of Human Rights Acts 1993. 66. How many insurance ombudsmen are there at present? How many insurance ombudsmen are there at present? Answer is option C, 17. The Insurance Ombudsman scheme was created by the government for individual policyholders to have their complaints settled out of the courts system in a cost-effective, efficient and impartial way. At present, there are 17 insurance ombudsmen in different locations. 67. Which article of the Indian Constitution makes provision for delimitation of the electoral boundaries? Which article of the Indian Constitution makes provisions for delimitation of the electoral boundaries? Answer is option D, Article 82. The Article 82 says readjustment after each census of the Constitution of India makes provisions for delimitation of the electoral boundaries. It is the process of allocation of number of seats and their demarcation into territories. Which of the following is correct regarding Union Public Service Commission? 1. It is the watchdog of merit system in India. 2. Conducts recruitment to the All India Services and Central Services Group A and Group B. involved in classification of services, pay and service condition, cadre, management and training. So select the correct option from the codes given below. The answer is option B. Only 1 and 2 are correct. The Union Public Service Commission is the watchdog of merit system in India. It conducts recruitment to all India services and central services, Group A and Group B. That's the central services. The list is Group A and Group B. It is not involved in classification of services, pay and service conditions, cadre management and training. These matters are handled by the Department of Personnel and Training. Which article empowers the Parliament and the state legislature to regulate the recruitment and the conditions of service of the person appointed to public services? The correct answer is option D, 309. The Article 309 of the Indian Constitution empowers the Parliament of India and the state legislatures to regulate the recruitment and the improve the recruitment and the conditions of services of the persons appointed to public services and post under the center and the states respectively. So the Article 309 of the Indian Constitution says that, or it empowers or it gives powers to the Parliament of India and the state legislature for what? To regulate the recruitment and the conditions of services of the persons appointed to the public services and post under the center and the state respectively. What is the maximum number of chairperson and member of a National Human Rights Commission? What is the maximum term of the chairperson and the members of the National Human Rights Commission? Answer is option B, 3 years. The chairperson and the members of the National Human Rights Commission hold office for a term of 3 years or until they attain the age of 70 years, whichever is earlier. Who appoints the chairman of National Commission of Scheduled Tribes? So it is the president. The answer is option B, president. The chairman and the members of National Commission for Scheduled Tribes are appointed by the president by warrant under his hand and seal. Their conditions of service and tenure of office are also determined by the President of India. Next question. Which of the following are the ex-officio members of National Human Rights Commission? 1. Chairperson of the National Commission for Minorities. 2. Chairperson for the National Commission for SCs. Chairperson for the National Commission for Protection of Child Rights. Select the correct option from the codes given below. So the correct answer is option D, 1, 2 and 3. The National Human Rights Commission consists of 7 ex officio members. The chairperson of the National Commission for Minorities, the National Commission for SCs, the National Commission for STs, the National Commission for the Women, National Commission for Women, then National Commission for the BCs, then the National Commission for Protection of Child Rights, and the Chief Commissioner for a person with a disability. So these are the National Human Rights Commission consists of these 7 ex officio members. Question: in which year National Commission for Protection of Child Rights was set up? The answer is option C, 2007. The National Commission for Protection of Child Rights was set up by the Government of India in March 2007 under the Commission for Protection of Child Rights Act 2005 and Act of Parliament December 2005. Next is, who is authorized to remove the Chief Information Commissioner or any Information Commissioner from the offices? Answer is option B, President. The President is authorized to remove the Chief Information Officer or the Commissioner or any Information Commissioner from the office on grounds such as if he is adjudged or an insolvent, or if he has been convicted of an offence which in the opinion of the President involves a moral turpitude, etc. Who appoints the State Chief Information Commissioner? Answer is option C, Governor. The State Chief Information Commissioner was Commissioner, and the State Information Commissioners are appointed by the Governor on the recommendation of the committee consisting of the Chief Minister as chairperson. I repeat it once more. The State Chief Information Commissioner and the State Information Commissioner are appointed by the Governor, from whom, on the recommendation of whom, on the recommendation of a committee consisting of the Chief Minister as chairperson. Chief Minister as chairperson. Next question: which of the following statement is correct regarding Attorney General of India? He is a full-time counsel for the government. He falls in the category of government servants. He is not debarred from private legal practice. Select the correct option from the codes given below. The correct answer is option C, only 3. Only 3 is the correct answer. Means he is not debarred from private local legal practice. And the Attorney General of India is not a full-time counsel for the government of India. He declared it's not declared. He does not fall in the category of government and servants. Also, he is not prohibited from his from private and legal practice. He is also prohibited from the private and the legal practice. Next question. Question 77. Which article of the Constitution of India mentions the powers, privileges and immunities of Attorney General of India? The answer to the question is option D, 105. So option D, 105 is the answer. And the article 105 of the Constitution of India mentions about the powers, privileges and immunities. The powers, privileges and immunities of Attorney General of India, whereas the rights of Attorney General as respects the House of Parliament and its committee are stated in Article 88. So the rights of Attorney General come in the Article 88, and the power, privileges and the immunities of the Attorney General comes in the Article 105 of the Constitution. Next question, 78. The Unique Identification Authority of India was constituted in which year as an attached office under the aegis of Planning Commission? Answer to the question is option C, 2009. The Unique Identification Authority of India (UIDAI) was constituted in January 2009 by the Government of India as an attached office under the aegis of the Planning Commission of India. Question 79. Who was the chairman of the Advisory Planning Board constituted in 1946, which recommended for the creation of Planning Commission? So, answer is option A, K.C. Negi. K.C. Negi. The Planning Commission was constituted in 1950 by an executive resolution of the Government of India on the recommendation of Advisory Planning Board, which was constituted in the year 1946 under the chairmanship of K.C. Negi. Next question 80. What is the maximum fine under Whistleblowers Protection Act 2014 for false or frivolous complaints? So the answer is option C, 30,000 rupees. 30,000 rupees is the answer to the question. The Whistleblowers Act of 2014 lays down punishment of up to 2 years in prison and fine up to 30,000 for false or frivolous complaints. It provides for a system to encourage people to disclose information about corruption or the willful misuse of power by the public servants in India. Question 81. Who appoints the Advocate General of the state? Who appoints the Advocate General? Answer is option D, Governor. The Governor is the one who appoints the Advocate General. The Advocate General of the state is must be a person who is qualified to be appointed as a judge of a high court of a state. So he is appointed by the governor of the state and he must be qualified to be appointed as a judge also for the high court of the state. Question 82. Central Vigilance Commission (CVC) was established in which year? Answer is option C, 1964. The Central Vigilance Commission was established in the year 1964. It was established on the recommendation of the Santhanam Committee on Prevention of Corruption. That was in the year the Santhanam Committee on the year 1962 to 64. Next question 83. Where is the headquarters of Central Vigilance Commission (CVC)? The answer is New Delhi. The headquarters of CVC is in New Delhi and the CVC conducts its proceedings at its headquarters only. The Central Vigilance is vested with the power to regulate its own procedure. So it has the power to regulate its own procedures. Question 84. What is the limitation period for filing complaints under the Lokpal and the Lokayut Act 2013? Answer is option C, 7. One major drawback of the Lokpal and Lokayut Acts 2013 is that the limitation period for filing complaints is 7 years. 85. In which year the Parliament of India enacted the Official Languages Act? It was in the year 1963. So the correct answer is option A, 1963. The Parliament of India enacted the Official Languages Act in the year 1963. These acts provide for the continued use of English language even after the year 1965, in addition to Hindi language for all the official purposes of the Union of India and also for transaction of businesses in the Parliament. Next is who can authorize the use of Hindi or any other official language of the state in the proceedings in the High Court of the state? Answer is option C, Governor. So the Governor of the state with the previous consent of the President of India. So it's not his decision alone. He needs the consent from President of India too. It's from the previous consent of President of India can authorize the use of Hindi or any other official language of the states in the proceedings of High Court of the state. Next question is which of the following has the power to specify as to what caste or tribes in each state and union territory are to be treated as the SCs and STs, SC and ST. So the answer is option B, President. The President of India has the power to specify what caste or tribes of tribes in each state and union territory are to be treated as scheduled caste and scheduled tribe. The Constitution of India does not specify anything about that. So it is the President of India who has the power to specify. So who can be treated as a scheduled caste and who can be treated as a scheduled tribe. There is no relation or there is no decision making about that in the Constitution of India. Question 88. With respect to the criminal liability of a child, which of the following statements are valid? So the answer to the question is, correct answer is B. Infants are not endowed with the discretion to distinguish between right from wrong. So an act committed by a child under 7 years is not considered an offence as they are not in a position to distinguish between right and wrong. So the children cannot decide between right and wrong. So the act committed under 7 years of age is never treated as an offence. So that is the wrong, that is the valid statement in the question given above. What are the principles of doctrine of private defense? What are the principles of doctrine of private defense? The answer to the question is all of the above. Following are some of the principles of doctrine of private defense. One is anybody whose life is threatened by a grave danger need not wait for the state aid unless such an aid is available. Second one is it is protective or preventive and not punitive. And the third is the right cannot be availed for the sake of self gratification or to satisfy one's malicious intent. And the last principle is the right must be exercised when there is a real and immediate threat and a reasonable apprehension of such threat. So these are the principal doctrines of private defense. So it can be used only only when there is grave danger that you have to react to it. Question 90. An abetment is committed by which of the following? 1. By instigating a person to commit an offence, by engaging in a conspiracy to commit it. 3. By intentionally aiding a person to commit it. Select the correct option from the codes given below. The answer is option D, 1, 2 and 3. So all the 3 options given in the question are correct. An abetment is committed in the following cases. 1. By instigating a person to commit an offence, means provoking a person to commit an offence. Then by engaging in the conspiracy to commit it, means by helping the person or giving ideas or thoughts to perform that particular crime. Then third is by intentionally aiding a person to commit it. So intentionally helping a person to commit that particular crime. So all this commanded together it can be called as the abetment. Question 91. Criminal law of India is codified in which of the following? 1 is Indian Penal Code 1860, 2 Criminal Procedure Code 1973. Select the correct option from the codes given below. The answer is option C, both 1 and 2. Criminal law of India is codified in Indian Penal Code 1860 and the Criminal Procedure Code 1973. The Indian Penal Code is a substantive law where the Criminal Procedure Code is an adjective or a procedural law. Okay, the Penal Code is an substantive law, whereas the Criminal Procedure Code is an adjective or a procedural law. So what is a substantive law and what is a procedural law? So substantive law is something that deals with the rights and duties of people or organizations, etc., rather than dealing with the legal processes related to it. So Indian Penal Code just deals with the rights and duties of the people or organization rather than dealing with the legal processes. Whereas the procedural law or the adjective law is the one that deals with the legal processes such as rules for presenting information in court rather than with rights and legal responsibilities related to it. So penal code is a substantive law and criminal procedure code is an adjective or procedural law. Next question, which section of IPC states that if any person of unsound mind or mentally ill person commits any offence due to his unsoundness of mind, not capable of knowing the nature of the act, having no knowledge of wrong or right or law, is no offence? The answer to the question is section 84. The section 84 says that section 84, the correct answer is option C, section 84. The section 84 of IPC states that if any person of unsound mind or mentally ill person commits any offence due to his unsoundness of mind or not capable of knowing the nature of the act, having no knowledge of wrong or right is wrong or right, or he doesn't know anything about the law, then it is not an offense. Nothing done by a person is treated as an offense where at the time of doing it he is in an unsoundness of mind or is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to the law. So the section 84 says that is no offense. So the question is, who was the first chairperson of National Green Tribunal? The answer to the question is option B, Lokeshwar Singh Panta. The Lokeshwar Singh Panta. B is the correct option. Justice Lokeshwar Singh Panta became the first chairperson of National Green Tribunal on 18th October in 2010. The tribunal handles the expeditious disposal of cases that is pertaining to the environmental issues. This National Green Tribunal, it is mainly tasked with providing effective and good remedy in cases that is relating to the environmental protection, conservation of forest and other natural resources, and enforcement of any legal right that is relating to the environment. So the chairperson is Lokeshwar Singh Panta. Which amendment to the Wildlife Protection Act 1972 has made punishment and penalty for offences under the Act more stringent? The answer is option C, Wildlife Protection Amendment Act. Wildlife Protection Amendment Act of 2002. Here is important, 2002. The Wildlife Protection Amendment Act of 2002 to the Wildlife Protection Act 1972 has made punishment and penalty for offences under the Act more stringent. The Banking Regulation Act 1949 gives which of the following the power to license banks have regulation over shareholding and voting rights of shareholders? The answer is option A, Reserve Bank of India. The Banking Regulations Act of 1949 gives RBI the power to license banks, have regulations over shareholding and voting rights of shareholders. It gives RBI the power to supervise the appointment of boards and management. Question 96. The human immunodeficiency virus and acquired immunodeficiency syndrome Prevention and Control Act was enacted in which year? The answer is option B, 2017. The human immunodeficiency virus and acquired immune deficiency syndrome. Its Prevention and Control Act which came in 2017, or the HIV AIDS Prevention Act provides for controlling and preventing of HIV AIDS and securing the rights of individuals diagnosed with HIV AIDS. The Sexual Harassment of Women at Workplace, that is Prevention, Prohibition and Redressal Act, was passed in which year? The answer is option C, 2013. The Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act in an Act of Parliament of India in the year 2013. It seeks to protect women from sexual harassment at their place of work. So this Act was passed in the year 2013 to protect the women. Question 98. Which of the following are part of National Food Security Act 2013? One is Midday Meal Scheme, 2 Integrated Child Development Service Scheme, 3 Public Distribution System. Select the correct option from the codes given below. The answer to the question is option D, 1, 2 and 3. The correct answer is option D, 1, 2 and 3. The following schemes are the part of National Food Security Act of 2013. The Midday Meal Scheme, Integrated Child Development Service Scheme, Public Distribution System. Question 99. The Prohibition of Child Marriage Act was passed in which year? So the answer to the question is option B, 2006. So 2006 was the year when the Child Marriage Act, the Prohibition to Child Marriage Act was passed. The Government of India passed the Prohibition of Child Marriage Act in 2006. It came into force on 1st November 2007. It came into force on 1st November 2007. The objective was to prohibit solemnization of child marriage and its connected and incidental matters in India. So, to take into account and prohibit all the things that was related to the child marriage and its connected matters. Question 100. The Citizenship Amendment Act 2019 relaxed the residence requirement for naturalization of migrants of 6 religious minorities from Pakistan, Bangladesh and Afghanistan from 12 years to how many years? The answer is option C, 6 years. Option C is the correct answer, 6 years. The Citizenship Amendment Act 2019, it relaxed the residence requirement for naturalization of migrants of 6 religious minorities from Pakistan, Bangladesh and Afghanistan from 12 years to 6 years. That's all with the 100 questions from political science. Hope this session was informational for you all, and please do keep revising the questions so that the answers get registered in your memory and help you for attending or help you with the UPSC preparations. And thank you for being with this video from the Defense IAS Academy. If you like the video, please do subscribe to Defense IAS Academy, and please do share this video to your friends. Thank you.